Hello, my name is Brendan Dunn, and I'm a partner in the Public Law and Policy Group here at Akin Gump. Today I want to talk to you about one of the more unusual features of the recently enacted bipartisan infrastructure legislation, and that's the information reporting regime for digital assets, including cryptocurrency and possibly NFTs. Cryptocurrency is probably one of the more atypical items that you would expect to find in a very traditional infrastructure bill. The infrastructure bill that was enacted into law at the end of last year was a long pursued agenda item for both Republicans and Democrats, including massive new investments in the nation's critical infrastructure, including roads and bridges, rail, highways, water infrastructure, energy infrastructure, and even broadband. The challenge becomes how to finance all of those new programs, particularly when Congress has already made a determination that they are not going to raise taxes in order to pay for those programs. In a situation like that, industries that you wouldn't ordinarily expect to make an appearance in an infrastructure bill all of a sudden end up on the agenda, and one of those is the cryptocurrency space. Congress decided, in order to finance this new infrastructure bill, that one of the items they would tackle is information reporting for digital asset transactions, similar to what already is required for cash transactions. So for example, under the new law, the recipient of $10,000 in digital currency in one transaction or in a series of related transactions would be required to report the sender's taxpayer information number to the IRS for tax administration purposes. That seems easy enough, but was already fairly complicated and controversial. What became even more controversial very early on in the discussions in the United States Senate was the decision to require brokers of cryptocurrency transactions to file an information return with similar information. The challenge that was raised is that the definition of broker appeared to be much broader than was possibly necessary, bringing in not only miners, but software providers for cryptocurrency exchanges that might not have the relevant taxpayer information to provide to the IRS. This caused a significant debate in the United States Senate as this bill was being put together in the summer. Unfortunately, no amendment managed to pass the Senate, which would have provided greater clarity in this space. And eventually, in the fall, the House of Representatives passed the identical Senate bill without any amendment. Fortunately for those operating in this space, there are some options available that would provide some much needed definitional clarity. The first is with the Department of the Treasury. They obviously have significant regulatory leeway in the implementation of this law, and already members of Congress are reaching out to Treasury to see that any new regulations related to cryptocurrency and other digital transaction reporting don't put undue burdens on this new and important industry. Second, in the event that Treasury doesn't act, legislation has already been introduced and policies have been proposed in the House and the Senate to provide the clarity that was absent in the final legislation. The attorneys and professionals in the Public Law and Policy Group at Akin Gump and elsewhere within the firm are going to be monitoring these developments as they unfold over a period of months and probably over a period of years. If you have any questions, please feel free to reach out.